Hello, everybody. Thank you for joining us this morning. We will go ahead and get started since our numbers are kind of slowing down. So this morning, we're going to talk through ADA compliance and what your company leadership needs to know when navigating the ADA processes. If you've joined us before, I'm Sophie Dietrich, the HR professional for the Compliance Center here at Wagner, Falconer, and Judd. And we are, dedicated to supporting you as the business leaders with any human resource and employment law questions. Some quick housekeeping items before we get started. Please send your questions to us via the chat option at the bottom of your screen. There should be a Q&A there for you. And also, so you're aware, this webinar is being recorded. So with those items covered, let me introduce you to our presenter, Janelle Stanton. She is a senior associate with the employment law team here at Wagner, Falconer, and Judd. If you've joined our webinars before, you know Janelle brings 9 years of employment law and business litigation experience to the team, and she shares that expertise by counseling business leaders like yourselves on maintaining compliance with all of those laws that we are subject to. So she is our personal favorite thought leader. And as always, we are very excited to have her share with us today. So thank you again, everybody, for joining. And with that, I'll hand things over to Janelle.
All right, awesome. Thank you so much, Sophie. I'm sorry we're all running a little bit late. Tech snafus for me, so my apologies. But glad we were able to get connected here. So happy to have you all attending this week or this presentation. This is a super important topic, and I would tell you, and Sophie would probably agree, that we are advising clients on this issue every single day. By far and above, one of the most common questions that we receive here at the Compliance Center are those questions relating to the Americans with Disabilities Act. And the reason we feel that this is such an important topic for us to be covering with you is because of the high cost of ADA litigation. And I'll kind of give a specific case study of just how high that cost can be. I'll give a little bit of background about the ADA. The crux of what we're going to talk about today is the interactive process and how to manage those really tricky ADA issues. At the end, I'll talk about some of the most common employer pitfalls, but most importantly, how to avoid them and how to comply with the ADA as best you can, and avoid any of this litigation that seems to pop up. So as an employment attorney, I'm always sort of keeping my finger on the pulse of what's going on out there. What are these cases looking like? What are they settling for? So that when I'm talking to you guys and my other clients, I can talk about just how critical it is to be compliant with these various laws. And this one rolled across my desk around the beginning of last month, which doesn't seem possible. I don't know how it's almost Thanksgiving, but somehow we are just landing right at the end of 2023 here. So the EEOC, the Equal Employment Opportunity Commission, is of course the federal agency tasked with enforcing the Americans with Disabilities Act. So when employers run afoul of the ADA, plaintiffs, employees they can file a charge of discrimination or failure to accommodate under the ADA with the EEOC. And if the EEOC feels that there is a valid claim there, they can actually bring a lawsuit against the employer. And that's exactly what happened in this situation. So here, the Public Service Company of New Mexico, PNM, they were alleged to have failed to accommodate disabled employees. And so they had a group of employees. This is a few employees who brought this claim that alleged that they were qualified employees with disabilities and that PNM failed to provide them with any accommodations. And then when they asked for accommodations, that PNM retaliated against them by terminating them. So not only did they fail to provide accommodations as required under the law, they took the next step of saying, and now that you have requested these accommodations, we're going to fire you. So here PNM reaches a $750,000 settlement with these plaintiffs who brought this claim. And I mean, $750 or $750,000, sorry, is extremely expensive on its own, but you have to think of some of the other costs here, both tangible and intangible. Tangible cost, number one, is attorney's fees. So if they didn't have EPLI coverage and were paying out of pocket for their defense, that could be, anywhere from $75,000 to $150,000 in additional attorney's fees. Now, if we want to talk about intangible costs, those are also extremely high. Think about how hard it can be to hire somebody right now. And most applicants who are out there looking for jobs, you can do just a quick Google search and you can say, Jesus, is the Public Service Company of New Mexico, is PNM a great place to work? Well, your employees or applicants can find this news article out there. It's a press release, it's public. Do you think that somebody who is going to want to come work for your company if they see that you've recently settled this large of a disability discrimination and retaliation case? Probably not. It's bad for employee morale all across the board. It has very high intangible costs as well. So it's really, really key and important to get these things right. The Americans with Disabilities Act, it's been around for a while now. It was enacted back in 1990, back when I was a young buck. And the point of it is to make it unlawful to discriminate in employment against qualified individuals with a disability. Unlike the FMLA, which applies to companies that have 50 or more employees, the ADA provides or applies to companies that have just 15 or more employees. So much smaller companies are required to comply with this. And even still, there are state laws that are very much equivalent to the federal ADA that apply to smaller companies. So, for example, the Minnesota Human Rights Act, the MHRA, which also prohibits discrimination on the basis of mental and physical disabilities, applies to companies that have just one or more employees. So again, very, very small. Not that any of you are in Connecticut, but if you are, or you have employees there, the Connecticut Fair Employment Practices Act applies to companies with 3 or more employees. They also have a more expanded definition of disability. That particular law in Connecticut protects folks that have mental disabilities, intellectual disabilities, learning disabilities, and physical disabilities. So it's more broadly worded. So something to keep in mind that even if you're, 14, 13, 12 employees, you may still have obligations under some of these state laws. So make sure you're aware of not only the state where you are, operating or where your operations are based, but the states where you have employees working need to be assessed as well. So what does the ADA do? It makes it an unlawful practice to discriminate against both applicants and employees with regard to all of the things listed here. And so one of the areas that I would say our clients or anybody kind of forgets about is that the ADA applies to job applicants, not just employees. So what that means is in your recruitment and hiring process, you may have obligations to provide reasonable accommodations to your job applicants to allow them to participate in the process. And this can look like a lot of different things. So for example, if you have an applicant who is visually impaired and it's difficult for them to, maybe your application has very small type, you might need to provide that application form in a different format that allows that visually impaired person to fill out the application. Um, you might have a place where you interview your job applicants that is not handicap accessible. And if you are interviewing somebody who is in a wheelchair, you may need to provide a different interview location to allow that applicant to attend a job interview. Maybe you interview them over Zoom, for example. So these requirements to accommodate folks begin very early at the application, at the recruitment and hiring process. But you also have to be mindful of basically every employment practice throughout the employee life cycle is touched here. You cannot discriminate on the basis of disability with regard to pay, promotion, job assignments, training, leave, layoffs, benefits. Firing, of course, you can't discriminate against qualified individuals with a disability. So getting into the meat of some of these definitions here. So what does disabled mean? And this was always very broadly defined, which you can see here. It became even more broadly defined after the ADAAA was passed in 2008. Yes, the ADAAA. We are very creative when we come up with these act names. So the ADAAA is the Americans with Disabilities Act Amendments Act. And so the ADA defined disabled as an individual who has an impairment that substantially limits a major life activity or has a record or past history of a substantially limiting impairment. So that's very broad, because what is a major life activity? Eating, walking, sitting, standing, breathing, your major bodily functions, your respiratory system, your circulatory system, your cardiovascular system. All of these things are major life activities where if you have an ailment, a mental or physical ailment that impacts one of those activities, that is a disability. And what did the ADAAA do? That particular law said that these disability is meant to be broadly construed in favor of granting protection under the ADA. So oftentimes, as employers, we are not getting into the meat of, does this person have a disability? Almost anything can be a disability. And I would say that this is not where we want to focus most of our time. Because if somebody says, I've got depression, probably that's a disability. I have alcoholism, that's likely to be a disability. This is not where our question lies. Where we want to spend more time is dealing with the other side. So, like I said, the Americans with Disabilities Act prohibits discrimination against qualified individuals with a disability. This qualified individual component is really important to understand, because the person has to be able to, with or without a reasonable accommodation, perform the essential functions of their job. If somebody has a disability to the extent that there is no reasonable accommodation for them to be able to perform their job, then you may not have to provide any accommodations, and you may end up parting ways with that particular employee. However, there's a lot to do between the disclosure of a disability and request for an accommodation and the decision to terminate that individual. And that big space in between finding out about the disability and taking action is called the interactive process. Now, lay people might hear interactive process and think, wow, geez, that sounds like a really fancy process and it sounds really, really intricate and hard. And I'm here to tell you it's not. Interactive process is just fancy lawyer speech for having a conversation with your employee. So, first things first, when do you, as the employer, have to engage in this interactive process? Well, you engage in this when the employee asks for an accommodation or a change to how they do their job because they have a disability. The tricky thing here is no employee pretty much that I know of, unless they've been sitting in my webinars or some other attorney's webinars, is going to come to you and say, hello, I am a qualified individual with a disability under the Americans with Disabilities Act, and I am requesting that we engage in the interactive process to determine whether there are any reasonable accommodations that can allow me to perform the essential functions of my job and don't cause an undue hardship to the company. Thank you. If you ever hear that, I promise you that person has a lawyer friend, a lawyer spouse, or is lawyer adjacent. And you should be very, very careful if that happens to you. More frequently, what's going to happen is an employee is going to say something like, geez, I'm going through a divorce, and this has just been an awful time in my life. My anxiety and depression are through the roof. I need some grace with my performance right now. I know I've not been doing a good job, but if you could look the other way, our final hearing's coming up, things are about to get better, and I'm getting treatment. I'm getting on some medications to help with this. Can we just look past my poor performance in the last month or two? That ticks all the boxes because now they've disclosed a potential disability, depression and anxiety, and they've asked for some grace or a change to how the employee does a job or an accommodation. And again, it can be sneaky, but there has to be both elements. If somebody says, oh God, I've just been going through a divorce, it's been awful, I'm so depressed, it sucks. There's no request for an accommodation in that statement. Lots of people suffer disabilities that they don't ever need a workplace accommodation for. So again, it's kind of a two-pronged test as to when that interactive process gets triggered. Now, again, do you want to spend a lot of time worrying about, well, is the interactive process triggered? If somebody discloses a disability, for example, in the divorce situation, and they say, God, I'm so depressed, you can say, I'm really sorry to hear that. Is there anything that we can do? Is there anything we can do? Can we do anything to help you? Is there anything you need from us? If the employee says no, then you go about your merry way. If the employee says yes, hear them out. And that then begins the interactive process. So I know some people might want to feel like they don't want to wade into or open up that can of worms, but depending on the conversations that this employee is having with their supervisor, with other folks, they may have already triggered the interactive process elsewhere and you don't know about that. So I don't think it's a bad practice to ask if they need anything from you. You're not required to, but you certainly can. If they have outright asked for some kind of accommodation or change to how they do their job, well, then the next step becomes engaging in the process. So first things first, you need to determine the essential functions of the employee's job. And this doesn't include just, hey, this person, they do our accounts receivable, so they take in the checks, they process the checks, they apply the checks to the balance, They make phone calls to customers when things are late. That's not all that I'm talking about. That's a great start. You also need to determine the environment that that person works in. So, and the physical requirements of the job as well. So somebody who's in accounts receivable, for example, needs to be able to type. They need to be able to talk on the phone. They need to be able to sit for long periods of time or alternate sitting and standing, for example. They work in an office environment that is got fluorescent lighting, and these are things that are really important to define. I know it might seem kind of silly a little bit, but I'll give an example of this. So our firm represents some grain elevators. And if any of you grew up in a small town or in a farming community, you know what a grain elevator is. If you didn't, a grain elevator is a place where farmers bring their grain and it gets processed there, and they separate the wheat from the chaff from the wheat, and they do all the things. It's a hot, dusty environment. So we had a grain elevator. They had a job description that just talked about, what the actual job was, but they didn't have those environmental factors worked into the job description. So what ended up happening was they hired an individual to work in their grain elevator who had asthma. And like I said, I've just told you, a grain elevator is a very dusty environment. So this guy comes in, he's working just fine for a few weeks. Then all of a sudden, he starts missing work. He's got to go to the doctor. His asthma is getting progressively worse. Pretty soon, he's getting hospitalized due to how bad his asthma is. And so he comes to HR there and says, gosh, I don't, this has been really hard for me. My asthma is really triggered. It's a very dusty environment. Well, of course it is, but it wasn't listed in the job description. And so, I don't know if he didn't know what a grain elevator is like or what, but essentially then my client got put in the position where they had to engage in this interactive process. So they had to reach out and get documentation from this employee's physician to say, yes, he has asthma. This work condition is exacerbating it to the point where he cannot work in that environment. And so we ultimately, even masking did not work for this guy. It was just so bad. So we had to see, are there any other positions at the elevator that this particular individual is qualified to perform? And unfortunately, there weren't. So they had to let him go. Had they had those essential functions in the environment that he was going to be working in spelled out in that job description, they may well have been able to avoid hiring this individual and, essentially wasting everybody's time by giving him a job he ultimately could not perform. So with that said, one thing I want to point out here, if you are hiring and you have an employee that has not reviewed the job description, make sure they know what the job description says. And while you can't ask somebody you're interviewing whether they have a disability, because that's illegal, you cannot ask that. What you can ask is, can you perform the essential functions of this job with or without an accommodation? If the applicant says yes, leave it alone and move on. If the applicant says, well, I'm probably going to need an accommodation. I have asthma. I don't know if I can work in a dusty environment. Then you can go through this interactive process to make the determination ahead of time. If you haven't done this though, and again, things crop up, people develop new conditions. So it's not something you can always weed out at the beginning, but the job description to spell out those functions is incredibly important. Again, we're not required to be physicians and medical professionals. So if somebody comes to you with some crazy ailment that you've never heard of in your whole life, it's not your job to understand that person's medical limitations. That is where you rely on the interactive process questionnaire that you give to the employee along with a copy of their job description, and you have their physician, their therapist, their psychiatrist, whatever their treating professional is, fill that document out, and then they give an opinion about what their unique limitations are as it relates to the job description and the functions of their job. So in the instance with the asthma, the grain elevator asthma guy, the physician originally said, well, this is too dusty of an environment. It's exacerbating his asthma. Let's try some N95 type masks. We tried it. It was ineffective. It did not reduce his symptoms. And so eventually the physician came back and said, the only way to accommodate him then is if there's a different position. And there just wasn't a different position that he was qualified for. And the ADA does not require that you make a new position. We had to let him go. But engaging in the process to determine those limitations and whether there are accommodations available is really key. And so once you know what those limitations are, that's where you start exploring potential accommodations. And I don't have it on the slide here, and this is an oversight on my part, and I apologize. If you have pen and paper, I would highly suggest writing this down. It's called JAN, the Job Accommodation Network. I don't know what genius wizards are behind this website, but it is a wealth of information. It has almost any disability you could possibly imagine listed, along with the common limitations of that disability and potential ways to accommodate that employee. So even though, and I'll tell you, those interactive process questionnaires that you guys are going to get back from physicians, they're almost always junk. The physicians they're not lawyers. They're not thinking about, these are the accommodations I need to put in there. So they're often not that helpful. They more are helpful to tell you that there's a disability and that there are limitations. That's often the most helpful information you'll get from those forms. So you may need to rely on some other resources to come up with creative ways to provide accommodations. And I really encourage you to think about everything before you start saying, that's too expensive, that's not going to work. Have the conversation. You might propose something to the employee. The employee might counter you, well, what about this? And you say, oh yeah, we could try that. You might try something, it could work for a while, and then it no longer works anymore. So you might have to change things. You just have this conversation back and forth, and you select the most reasonable accommodation. And here it's really important for me to point out, employees and job applicants are not entitled to the accommodation of their choice. If there is a different accommodation that's reasonable, that will allow the employee to do their job, you can select that as the employer. You don't have to just let them have whatever they want. This came up a lot with COVID. For example, people who have medical conditions or disabilities that made them at higher risk should they contract COVID-19, a lot of times employees were requesting to work remotely. And sometimes allowing employees to work remotely is a reasonable accommodation to a disability. However, I worked with one client who really needed employees in this particular job function to be in the building. It was very, very important. So what we did is we looked at, is there an office with a door that can close in a less populated area of the building that this person can start working in so that they can be separated from their coworkers and stay safe. And so we worked back and forth and ultimately proposed the office to the employee. The employee didn't super love it, but was ultimately like, yeah, I guess that works. And so it worked really, really well. The point being, it is meant to be some give and take. And I know I've got some questions here. So let me see. Oh, great question. And super good dovetail from what I was just talking about. Are you seeing an uptick in requests for accommodations to work from home due to employers' return to office requirements? Yes, absolutely. That is without a doubt. We are dealing with many, many more requests for remote or hybrid work arrangements after COVID-19. And, I know that remote work can give some of us a lot of heartburn because if we don't see employees every day, we wonder, are they working? Are they doing their jobs? And so while it can be a reasonable accommodation, if an employee does not perform well when they work from home, then you might be able to tell them you are not an effective remote worker. And you might need to explore some other accommodations that involve the employee coming back to the office to work and do their job there. I don't know if any of you have heard of the concept of a mouse jiggler. I know the first time I heard of mouse jiggler, I was literally thinking of somebody like jiggling a mouse. You can buy these things. They're a device and you can set them up, and it is a mouse jiggler. And every now and then it'll jiggle your mouse, your computer's mouse, so that it looks like you're active in things like Slack and Teams in Ring Central. And you could just be off laying on your couch watching Netflix, and this mouse jiggler is making it look like you're working. So people will do some really big, some really crazy and wild things to avoid getting their jobs done. But this is why we have performance metrics and other key indicators that will allow us to know whether somebody's actually getting their job done or not. There was a question in the chat. Oh, this is a great question. What if someone has poor performance and they don't disclose any issues during conversations for improvement, but then disclose when they are notified of termination? Yeah, so I have seen many, many, many times an employee throwing their hands up and saying, wait, 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 I have a disability, as a defense to possibly getting terminated, where they see that the writing's on the wall and all of a sudden now there's a disability. Oh boy. Well, yes, this throws lots of wrenches in our process. If you've got all this documented poor performance, you've had conversations, they're all well documented, you're going to move to termination, maybe they didn't improve on their PIP, and all of a sudden now they say, well, my poor performance is related to depression issues I've been suffering. Like so frustrating, right? And so realistically, what you need to do is you do need to probably at least engage in an interactive process before you terminate. You'll probably need to pump the brakes. And again, if somebody is just full of it and they don't actually have a disability, when you say, okay, well, we need to have your physician fill out this interactive process questionnaire. Here's your job description. And sometimes that is enough to scare off the person who's like, oh, well, I'm not getting any treatment for it. Well, yeah, okay. Well, there's there has to be some kind of actual disability for you to point to in order to get any kind of accommodation. And you might have to look at seeing if there is a way to accommodate them. But again, I think you have to go through the process, but I'll talk in a little bit about disciplining employees with disabilities. I'll also talk about disciplining employees that are being accommodated. It can be done, but what it's going to come down to is your documentation. Do you have documentation that predates the disclosure of the disability about the poor performance? Does the poor performance relate to the disability? It may not, because just because somebody has a disability, that doesn't mean that that is what's weighing on their performance. Their performance might just be because they're not very good at their jobs, and now they're just using that disability as a defense to being terminated. So you do need to think about it. You need to engage in the process, determine whether that poor performance is related to disability. And if it's not, again, then you probably end up parting ways. But here's where documentation is super, super critical. So I kind of talked about this a little bit. Reasonable accommodations are an assistance, type of assistance that you provide, or a change to the position or the workplace that allows an employee to do their job despite having a disability. So this can look like something as simple as providing a standing desk so that somebody can alternate sitting and standing throughout the day. It could be giving somebody a stool, allowing them to have a bottle of water and a snack with them. If you prohibit food and somebody is a diabetic, for example, you might have to allow them to have a bottle of water and a snack nearby. Essentially, there's lots of different things, providing a quiet space, providing noise canceling headphones. Lots and lots of things can be a reasonable accommodation depending on what the specific disability is. Now, you may also need to modify a job to remove marginal functions. So, let's say you do have somebody who's an office worker and their primary job is doing accounts receivable. They're mostly sitting at their desk all day long. If one of their marginal functions is to unload the truck that delivers the big boxes, the big reams of paper, the big jugs of water, and that person has like a disc disorder and they can't lift more than 10 pounds or something, maybe that's a marginal function that you remove and you assign to somebody else. And that's perfectly reasonable to do. I already talked about job reassignment, but I think it bears repeating. Job reassignment, it's an accommodation of last resort. And you only have to reassign an employee if you have an open position. So it has to be open. You don't have to create it. And the employee has to be qualified for it. So again, if we go back to my grain elevator situation, that individual could not perform the job they were hired for. And there were not other positions at the elevator that this particular employee was qualified for. So it's an accommodation of last resort. It's not the first step. We have to look at other ways to accommodate first. If there are other open positions the person is qualified for, reassignment might be your last ditch effort way of providing an accommodation. Of course, there is a sort of get out of the accommodation free card that employers may have. And that is if providing the accommodation would be an undue hardship on your business. I will tell you, this is a very, very high bar to reach. There has to be significant difficulty or expense involved. So there are some accommodations that would be extremely cost prohibitive. There are different types of software, just different things that could be very expensive for the company. Here's where prolonged accommodation by leave can get very expensive. We'll touch on that in just a minute here. But you do not have to continue to provide accommodations if it would be an undue hardship, significant difficulty or expense providing that. So another type of reasonable accommodation, I'm sorry, I've got the slides a little out of order here, can be unprotected or unprotected, protected, unpaid job protected leave. So some of you might be familiar with this. In certain circumstances, providing an employee with a period of unpaid job protected leave may be a reasonable accommodation. This means that you might have to give somebody time away to, attend a drug treatment program, time away to additional time away after FMLA is exhausted to heal from surgery. This can extend medical leave periods. So you need to be aware that if the FMLA is exhausted for a particular employee, the ADA may kick in and provide some additional leave. Now, the unfortunate and difficult thing here is the FMLA, if you're a company that's subject to it, it's very specific. You get 12 weeks. 12 weeks is 12 weeks is 12 weeks. You get 12 weeks in a whatever, your 12-month period is, measurement period. But the ADA has no such defined period. And you can find court opinions out there that say 2 months in a particular situation was a reasonable amount of time to provide leave. You can also find court opinions out there that say 2 months was an unreasonable amount of time. You can find court opinions that say 12 months was reasonable and other ones that say 12 months was unreasonable. This is extremely complicated. And the fact that there's no delineated amount of time that you might have to provide leave means you need to look at both the circumstances of that particular individual, but also any leave you may have granted to other similarly situated employees in the past. We had a client who they had an employee who was diagnosed with cancer, and that individual was not qualified for FMLA. They hadn't worked there long enough. And so they asked for leave under the ADA for a period of time. They were accommodating him, I think it was 3 or 4 months. They're like, look, we can't continue to accommodate this individual. Through conversations with the client, we found out they had accommodated a different employee a couple of years ago who had cancer for over a year. So they accommodated somebody before for over a year, but now this guy, they just wanted to give him 3, 4 months before they were showing him the door. Well, your past practices make a big difference here. So you do have to be mindful of that and look at everything on a case-by-case basis. So I want to get into talking about some of, and please keep submitting questions. I love the questions. So if things are coming up, put them in that Q&A section there. Accommodating mental illness is extremely difficult. Mental illness is very prevalent in American society today. There are some really shocking statistics that show that lots of Americans suffer some type of mental illness, whether that's anxiety, depression, bipolar, ADHD, PTSD. It's extraordinarily common, and it's a very challenging thing to accommodate because, an episodic flare-up of asthma, a migraine disorder where you maybe get a migraine a couple times a year, where it's episodic and not so frequent, those are easily defined, very easily defined if somebody's recovering from a surgery, as another example. Psychiatric ailments ebb and flow, and you can have them your whole life. And sometimes they're, if you're bipolar and you have a manic episode, you can be manic for a while and then you can be depressive for a long stretch of time. And it gets to be very challenging because it can be hard to know when you can stop providing accommodations and when you have to continue. So, this is where thinking about other accommodations for employees becomes really critical when you're looking at accommodating mental illness. So I just put a few examples here. Somebody who has ADHD, for example, that has issues concentrating or they are very prone to distraction. Maybe allowing them to work from home, giving them more frequent breaks or a quieter work environment might help them be able to perform the functions of their job and actually get them back to work. Somebody who's starting a new depression medication. Many of you know this, some of you might not. When you start a new medication for some of these ailments, it can take up to 30 days or longer for the medication to take hold and do what it needs to do in your body. So you might need to give some unpaid time for somebody who is starting a new medication to allow that medication to get up to full effectiveness for them, or give them a part-time schedule until their medication plan stabilizes. Somebody who suffers from anxiety, again, white noise headphones or noise canceling headphones, allowing some work from home or exchanging non-essential job tasks with another employee. If somebody's experiencing a high rate of anxiety and making calls to your customers is really provoking, but you can give that task to somebody else for a while. That might be reasonable. In some circumstances, it certainly won't. But accommodating mental illness is challenging. I would say almost as challenging as accommodating alcoholism and drug addiction. So they can both be disabilities under the ADA, but they are treated very differently. Alcoholism is almost always a disability under the terms of the ADA. Drug addiction, individuals who are currently using illegal drugs are not protected under the ADA. However, somebody who is a former drug addict and is clean now or is going through a treatment process, they may be protected by the ADA. The difficult thing, of course, is to define what is currently using. What does that mean? Does that mean yesterday and now today I'm clean? Does that mean a month ago? It's very unclear. So if you have an employee who is addicted to some type of illegal drug, ask for an accommodation. Be extremely careful in assessing whether it's current use and you deny an accommodation saying they're not protected. So again, just something to be mindful of. And I kind of touched on this as well. Accommodating employees for long periods of time is oh so challenging. I wish that our legislators would come up with a time frame that's reasonable under the ADA. At least give some guidelines or some parameters. There are none. The only thing that I've seen that's even remotely helpful is that a request for indefinite unpaid leave is not reasonable. It has to have a definite end date in order to be reasonable. But any of you who actually gone through this know that those end dates are moving targets. So a physician might say they should be better and able to come back to work November 15th. November 15th rolls around, all of a sudden it's December 15th. December 12th rolls around, now it's March 1st. You see where I'm going with this. When does it become unreasonable? It's very challenging to know. And I can't even tell you with any modicum of specificity what is a reasonable and unreasonable amount of time. The best we can do is look at the current circumstances of this particular individual and then weigh that against what the company has done in the past. And then gold standard is if you can work with an attorney like me to do some research in the jurisdiction where you're located to see what the court has said about what is reasonable or unreasonable in those particular circumstances. So this is a challenge for lots of companies, and I know that in our we meet 3 times a week here internally. Our attorneys and HR professionals, we get together and we talk about these, and we discuss how complicated it is and how we're going to recommend that our clients move forward. So this is one of the most challenging accommodation issues. So I do want to touch on disciplining employees that have disabilities or who are being accommodated. People get very nervous about disciplining an employee after they come forward and disclose a disability, even if they have poor performance. The EEOC put out a guide. This guide, it's important to know, does not have the force of law, but what it does do is it tells you how the EEOC would look at any potential claims that your employee might bring to them, asserting disability discrimination. So they are very helpful. But employees that have disabilities can be held to the same production standards, the same quantitative or qualitative standards as your non-disabled employees in that same position. So this is where having key indicators of success, key metrics, KIPs, other, being able to really clearly define when an employee is doing a good job and when an employee is not is really, really critical so that you can enforce those same standards against that individual who has a disability. And again, you have to be mindful that if the poor performance is caused by a disability, you may need to sort of tolerate some, poor performance while you find accommodations that allow them to get their performance standards back up. So giving notice of those standards. And again, you don't have to lower production standards, but if you provide an accommodation and that accommodation does not work, does not fix that performance, well, the writing might be on the wall. Again, you might have to terminate that particular individual. But the gold standard here is your documentation, is making sure that you have very carefully documented all of the poor performance indicators, all of the reasonable accommodations you've given, all the things that you've tried that aren't working, that aren't improving performance, and it's just not something that you can continue to tolerate any longer. So I saw some questions roll in here, so let's see. Oh, somebody has to jump off. All right, thank you so much. Happy Thanksgiving to you too. All right, we'll have the recording, of course. So, couple of things. Most common pitfalls, like I said, retaliation, I think, is one of the most common pitfalls that I see. And, very infrequently is an employer just like, wow, you've requested an accommodation for disability, you're fired. It doesn't look like that. What it looks like is somebody requesting an accommodation who's probably already a poor performer, has poor attendance. They're already on your radar for performance improvement or possibly separation. And then all of a sudden they raise a disability. And if you fire them within any proximity to that disclosure, well, maybe it looks like it's for retaliatory reasons. It's often not the case, but perception is reality with employees. So you do have to be really careful for not to ensure that your actions do not look retaliatory once somebody asks for an accommodation or discloses a disability. Another one is failing to realize that an employee has requested an accommodation. A lot of your frontline managers may not understand when something rises to the level of triggering the interactive process. That's why it's incredibly important that you train all of your frontline managers to realize when an accommodation request has come through. It's also really important that I recommend you have a central person, a team of persons who are handling all accommodation requests. If you have 5 different managers, you're going to have 5 different ways of handling these things. And like I said, your past practices are really crucial for helping you determine how you deal with the new accommodation. So by having one team deal with all accommodation requests, that's the gold standard. And then denying an accommodation without engaging in the interactive process. There was a case, I think it was out of California. I haven't picked on California yet today, so here you go. Here's uh, my jab at California for the day. There was an employee who was applying for a job as a real estate agent, and obviously, as part of your job duties, you have to be able to show your clients the house. Ooh, look at the marble countertops. Ooh, look at the rainfall shower head in the bathroom. Well, this real estate company, they had an applicant who was in a wheelchair apply for the job, and they, without doing any looking into how they could accommodate, denied this applicant. Their thinking was, well, this person can't get up and down stairs, so they can't show the waterfall shower head in the upstairs bathroom to potential clients. So they denied this person a job. Well, they didn't even engage in the interactive process. This person could look at the listing, could educate themselves about the features on different floors. So there were ways, the court found, that this employer could have accommodated that individual, and they violated the ADA by not even thinking about it. And I won't cover this. This is here just as a reminder that these penalties can get really, really expensive real quick. But like I said, how to stay on the right side of the law. I always like to end with this. Make sure you train your managers. Make sure you develop a solid policy and procedures for how you're going to handle any accommodation requests in the future. And of course, enlist the help of your friendly neighborhood employment attorney or SHRM certified HR professional, Sophie. And we are more than happy to walk you guys through these things because look, we get it. This stuff's complicated and not as clear as the FMLA is. So with that, I'll leave it to, I know we're up on against the time, but I was late, so I'm happy to stick around. If anybody has questions, feel free to throw them in the Q&A box or the chat box. Either way, I can access them. I'll give it just a few minutes here, but we really appreciate you guys joining our presentations, and we hope this has been helpful. Any lingering questions? If not, you can certainly always reach out to us. If you don't want to, bring it up online or you've got a complicated one, feel free to reach out to us and we'd be happy to advise you. So I don't see any questions coming in, but thank you so much again for attending and we'll see you at the next one.